There's a couple of things, I suppose, if you're having to work in a hostile environment, whether it's colleagues, managers. I suppose there's a couple of things to think of, both lack of support and hostility from colleagues, from anybody in the workplace, may well be against internal policies and procedures. There's likely to be an equality at work or dignity at work type policy in most organizations. So it could constitute a disciplinary offence internally. What I'd say there is check your policies and your internal procedures, raise it with your line manager, pointing out how this sort of undermines existing or breaches existing policies. It might also bring us back from an employment law point of view to the Equalities Act in terms of discrimination, because part of the Equality Act protects employees from harassment. Now, people use the term harassment, I'm feeling harassed, when they mean I'm feeling hard done by. And there is a definition. The definition for harassment in the Equalities Act is unwanted conduct related to a relevant protected characteristic. Now, that characteristic here would be disability. And as I said earlier, cancer meets that definition of disability for this act. So unwanted conduct related to disability in this instance, which has the purpose or effect of violating an individual's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. So we're talking here about hostile work environments. So it would make sense, if this is the case, to gather specific examples of this hostile behavior. Raise these with your employer. And it's key to point out the impact it's having on you. Because in a lot of cases, people say, I didn't mean it. I didn't know. It was just a joke. Now, in an employment tribunal, what will be scrutinized is the impact of the behavior on the individual more than the intent of the perpetrator. So if a colleague or an employer does say they were just joking, in a way it's irrelevant because it's about the impact on you. And if that correlates with that definition that is being hostile, could be liable. Well, when we talk about liability, if I, for instance, harass you, I could be individually liable, but there's also shared and vicarious liability. So if an act of hostility, which meets that definition of harassment, takes place in front of the manager, or you raise it with the line manager and they don't take any action, if they don't take reasonable steps to prevent or stop that kind of behavior, that's they're sharing the liability. If the organization doesn't take reasonable steps to prevent it, they are also at risk of vicarious liability. So it's in everyone's interest, not just morally, because it's the right thing to do, but also legally, to take these complaints seriously and act upon them accordingly. And don't forget, while we're talking about the employment law, there's this concept of victimization, which means you cannot suffer a detriment. You can't be put at a disadvantage for raising that complaint under the Equalities Act. So if you're concerned that I'm going to be seen as a pain and I'll be managed out the organization, that would meet the definition of victimization. And I think all of these are things that are sort of worth bearing in mind if you have these kind of concerns, pressing concerns, if you're returning to work after furlough. But again, what I would say is if you've got more specific, complex questions about life after furlough, then by all means, contact ACAS. Seek legal advice. You may have a trade union, you may have an employee assistance program that can offer as part of their sort of legal advice, or even some household insurance policies may cover the cost of legal advice. So it's worth checking those.